Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam. My name is Jaclyn Phillips, and today's episode is who should competition law work for? Enforcement against restrictive labor market agreements in the EU. Labor antitrust is a priority for enforcement agencies around the world. Globally, the type of conduct being scrutinized ranges from wage fixing and no-poach agreements to the classification of workers to non-compete agreements. The European Commission has been active in the labor arena, putting out guidelines that wage fixing and no-poach agreements, in other words, agreements involving labor among company employers, can violate Article 101, and are actively investigating suspected labor agreements. During today's discussion, we're going to hear more about how labor-related agreements have been treated under Article 101, how enforcement will be handled between EC and the national competition authorities, and what companies should be thinking about moving forward. My co-host today is Matthew Hall. Hey, Matthew.
Hi, Jaclyn.
Who's our guest today?
Thanks, Jaclyn. Our guest today is Johanna Kübler. Johanna is a founding partner of Commeo, a boutique German competition and antitrust law firm based in Frankfurt and established in 2010. She advises national and international clients on all aspects of German and EU antitrust law, with a specific emphasis on German and EU merger control, including all accompanying transactional issues, as well as cartels, abuse of dominance, and contract-related antitrust issues. Hello, Johanna, and welcome to the show.
Hello, Jaclyn and Matthew. Thank you very much for having me.
Well, by way of introduction, and as Jaclyn mentioned, our discussion today concerns the application of competition law in the EU to restrictive labour market agreements between companies. So we're going to be discussing agreements between companies which impact their treatment of their employees or contractors. We're not discussing collective bargaining by employees or agreements between companies and their contractors or employee non-competes, although we might refer to the latter briefly. As Jaclyn also mentioned, the key legal provision here is Article 101 of the Treaty on the Functioning of the European Union, which is the basic EU ban on anti-competitive agreements. Individual EU countries and many other jurisdictions around the world, including, for example, the UK, have very similar domestic laws. We're going to get on to this, and Johanna will tell us all about it, but there's an important distinction in Article 101 between object and effect infringements of competition law. The former are effectively automatic infringements. Importantly, and unusually for the EU and similar jurisdictions, Article 101 catches a wide type of information exchange arrangements where pure information is exchanged, commercially sensitive information, without necessarily there needing to be more of an arrangement in place. Another important concept we're going to discuss is ancillary restraints. If an agreement or restriction is part of a wider arrangement, it can fall outside Article 101 for that reason. So, Johanna, against that background, can you please just kick us off with a discussion, or kick off our discussion with an explanation of the basis for the analysis of labour market agreements under EU competition law?
Yes, happy to do that. Well, the basis for the analysis is indeed the general prohibition of agreements restricting competition, as you mentioned in Article 101 of the Treaty of the Functioning of the European Union. And in this context, we're looking at horizontal agreements. So we're looking at agreements between competitors. And so the initial question is, who are competitors when we're looking at labor markets? And the general view is that companies buy labor as an input. So we're looking at competitors in a procurement market. They don't necessarily have to be competitors on a downstream product market, but only on the upstream market for talent. That, of course, raises the question, when exactly is labor substitutable? So when do we have a competitive relationship? And that's an issue that's currently being discussed in a wide range, especially by economists, but also among lawyers. We have issues like geographic substitutability and how far are workers willing to travel, how much home office, work from home, mobile work can they do, what are the overall job characteristics, are there non-pecuniary benefits which are corresponding to non-price aspects of products, so quality issues, for example, could be, for example, a part-time thing that you're looking at. And of course, you have to have a matching between employer and employee. So it's a bit more specific than in usual product markets. And labor markets are very dynamic. So there is a lot of change going on in that respect. But having said that, I think a general perception is that if companies agree on something where they do not want to compete with each other, that only makes sense if they are, or at least consider themselves to be competitors, or at least potential competitors.
So as you say, there could be a distinction there maybe between, IT staff who could work remotely, and I'm looking at a recent one of your excellent meeting competition newsletters. You're looking at a German case there involving bus drivers who presumably can't do anything remotely. So what was that? Is that a good illustration here of how we might look at this?
Well, that's an interesting sort of deviation from the general concept of looking at a labor market as a procurement market, because in that case, the regional court in Germany took a different view on how to define the market. They were looking, it was an abuse of dominance case. That's probably an important issue to add. They were looking at a market for local bus driver jobs. So they were saying it's a supply market in which employers offer jobs, and then employees kind of purchase these jobs by providing their labor as price, as pecuniary reward. So that's slightly different. So in the end, the market definition was extremely narrow, which is common for abuse cases. As you know, authorities and also courts tend to go the way the market is where the abuse is. So this is quite specific, but indeed, yes, we have to look at the different roles, the different type of work that's being offered. Is it a technical expert? Is it a secretary, for example, or some writing that can be done for any industry? So yes, quite a different picture there.
So Jaclyn mentioned in her introduction briefly the types of restrictions which we might be looking at. I know that there seems to be a general agreement in the EU and amongst national authorities in the EU on the real key problematic restrictions here. So can you take us through what those are generally seen to be and what they actually mean with their brief descriptions, which are often used?
Yes, initially we're talking about wage fixing and no-poach agreements. The wage fixing agreements are agreements on employees' wages or salaries, and of course also other employment conditions or benefits. For example, holidays, mobile devices to be used, company car arrangements. So any aspect that is a component for an employee's remuneration can be part of that. And these are the essential competitive parameters for recruiting. So we're talking about, in a sense, a purchase price fixing. It has an immediate effect on employees and a negative effect on their working conditions when wages are being fixed. Having said that, just two brief exemptions to that. You already mentioned the collective bargaining agreements. These are, of course, not wage fixing. They're done by trade unions and the social partners. It's a transparent process. It's foreseen in the law. So that's one sort of exemption. And the other is a new EU guideline on collective agreements by solo self-employed people who have the chance to set out conditions in which self-employed people can jointly negotiate for working conditions. But that's also a transparent process. And of course, is based on the imbalance of the negotiating powers between the solo self-employed and the employers. And then secondly, the no-poach agreements are agreements not to hire employees from each other that can have the form of an active ban on poaching. So the companies agree not to poach each other's employees. It could also be an agreement not to hire employees based on unsolicited applications. And it can also be a more informal way of we will call each other and discuss if an employee approaches one or the other, whether that would be a move we accept or not. So there are different variations of that. That, of course, limits companies' autonomy in defining the human resource hiring policies and restricts employees and talents from moving, which in essence amounts to a market sharing agreement and to a less efficient allocation of resources. It hinders innovation, etc., but we can have a look at that also a little later. It also has an immediate effect on employees, of course, and can also be relevant in transaction scenarios, but we may want to have a look on that a little later.
Yeah, and I think it's important, as you just did, to point out what these actually mean in practice, because I think the European Commission certainly takes the view that these types of arrangements damage growth and productivity because of those economic harms that you were pointing out. And what about exchange of commercially sensitive information, or CSI, which I mentioned has a particularly individual treatment in many cases under EU and national competition law? And there's some link here, isn't there, with other areas like transparency obligations and benchmarking and operation of trade associations?
Yes, the exchange of commercially sensitive information is probably the most practical issue, or the most practical and common problem we're seeing in these areas. The exchange of commercially sensitive information reduces uncertainty in the market and is therefore seen as harming competition, because uncertainty is what competitors, what is an important aspect of competition when they decide on how to move forward. So this general concept in the labor market context means that, of course, no individual non-tariff salaries can be exchanged. And that works just as much as it does with pricing information and terms and conditions in the sale of product markets. So that's really an easy parallel to draw. You mentioned the transparency obligations, which I think are a bit more difficult to tackle. They can relate, for example, to gender pay gap issues. Very often, these are internal obligations. So within a company, you have to make transparent what the pay is. If it's external, so if it's also seen to the public, that would have to be aggregated in an appropriate way so that you cannot see individualized wages of individual companies. Similarly, we have these aspects in benchmarking reports or statistics when reports are being prepared showing average wages in certain sectors or for certain jobs. That is, I think, a common and important tool for employees to, make their choice of where do I want to go, where do I want to apply, what are my chances in a certain market. But that's also a transparent reporting. So usually that works. It can raise a problem of signaling if there's too much information in that, where companies give each other signals on where to move on to. So I think these benchmarking reports and statistics have to be watched really carefully. And a third aspect could be recommendations from trade associations. These are practical cases we are seeing, that trade associations are giving recommendations on specific wages or employee benefits for certain industries. That, I think, is a high-risk area and really a problem. And then finally, an issue that's not that much debated is how do you deal with external recruitment agents? They create an indirect transparency in the market because they get information on wages and employee benefits from a number of employers, very specific. And I think that's a space we watch to make sure that there's not too much information exchange going on indirectly via the recruitment agent.
Yeah, that's an interesting point. That's kind of a hub and spoke type arrangement, isn't it? And I think there's also some tension here, certainly between legal employment law disclosures, i.e. what you're actually being told to disclose, and how competition law might impact that. And also you've made some very good compliance messages, and I think we'll get onto that hopefully at the end. But let's just zoom out a bit. As Jaclyn mentioned in her introduction, the European Commission and national regulators in the EU are looking at these cases. There's been a bit of a movement, or kind of the Commission has been slowly focusing on this and making that clear over the years. So, and very recently there was a policy brief, which is a very important document they brought out. So can you just take us through the kind of evolution of what the Commission has said and where, and take us up to this policy brief for May 2024.
Yes, I think sort of a kickstart was a speech given by the EU Commissioner for Competition, Margrethe Vestager, in October 2021, which was post-COVID, where she made a statement that the Commission is sort of getting a refresh in enforcement of competition law infringement. The Commission wants to move on and not only go after agreements to fix final prices, but also to go after other arrangements, reference prices, price components. There was a famous case of the agreement not to compete on technology, the clean cars, the emissions case that was fined in July 2021. And also looking at the buyer side, there were a number of buyer cartels that the Commission went after because the Commissioner stressed that as bad as price-fixing cartels are, there's a lot more to the cartels. And the problem may not be higher prices for consumers, but less efficient economy as such, which of course leads to suppliers suffering and to the economy just not working as efficiently as it should. She explicitly mentioned wage fixing as having very direct effect on individuals and on competition. And when no-poach agreements are used, that this is an indirect way to keep wages down, restricting talent from moving where it serves the economy best. So she was very clear on the overall detrimental impact on the GDP, the gross domestic product, which is sort of seen as a kickstart. And I think that's fair to say. The head of the Dutch Competition Authority in 2022 still said competition law or enforcement in labor markets is still competition law's long neglected corner, as Martijn Snoek put it. But that, I think, has really changed. In July 2023, when the new horizontal guidelines by the EU Commission came into force, it's explicitly mentioned in the context of joint purchasing that a buyer cartel could also be an agreement to fix wages, and that this would be a by-object restriction, as you've already mentioned before. So that was the start. And since then, we've seen quite a lot of movement on the national level. And then the EU Commission published the EU Competition Policy Brief that you were briefly talking about in May 2024. These policy briefs are occasional papers by staff members of the European Commission about policy issues or key cases. They don't necessarily reflect the official position of the Commission, but it's usually a very useful indication of the Commission's current thinking on a particular issue. And here, this particular policy brief shows how labor markets agreements should be dealt with under EU competition law based on the opinion of these Commission officials. It focuses on the wage fixing and no-poach agreements I mentioned before. Interestingly, it does not touch upon the information exchange issue we just discussed. But it does describe wage fixing and no-poach in detail. It goes into aspects of economic harm, such as the low wage level that's created by wage fixing agreements, because you're creating an artificial monopsony, if you want. So purchaser power by a cartel agreement. Labor markets become less dynamic, so there's not an efficient allocation of labor force, and that leads to reduction of firm productivities and innovation. It increases employee search costs and reduces incentives to invest in training, and they cannot negotiate where they're actually going. So all of this is seen as strongly detrimental to competition, which is why the Commission or the policy brief reaches the conclusion that wage fixing and no-poach agreements are most likely by object infringements in most cases, which means there is no need to show negative effects of the agreement, but they're considered to be illegal as such. And that is irrespective of whether the agreement is bilateral or multilateral or sector-wide. This is not seen as a differentiating factor, but wage fixing is explicitly said to be purchase price fixing, and no-poach agreements are explicitly said to be supply source sharing, market sharing agreements, both being explicit prohibitions mentioned in Article 101. So that's a very sort of strict line of argument that's, at least at this point in time, I think, hard to get by.
As you say, a pretty clear view of the Commission in that document. These are by-object restrictions, also means that they're fairly unlikely to be exempted under Article 101 3 on the basis the efficiencies outweigh the anti-competitive elements. But an interesting part of that document, and I think highly relevant in practice really, is the discussion, which is actually fairly brief in there, of ancillary restraints and when these types of restrictions might be justified on that basis. So could you give us some of your thoughts on, well, what you've seen in practice and also what the Commission has to say about these in that document?
Yes, I fully agree that this is an aspect that's extremely relevant in practice. And I do think that many agreements on some sort of no-poach rules have to be redrafted following this competition policy brief, because now the view seems to be a lot more strict. The ancillary restraints concept is well known from other Commission guidelines on application of Article 101.3. The horizontal guidelines mention them, and of course also the ancillary restraints notice in the context of transactions. There's a number of European court decisions which help us in that. So it's a very familiar concept, and it has been used in the no-poach concept quite a lot. At least that's what we have seen in the past. The Commission now takes a pretty strict view and says ancillary restraints are essentially only possible in 2 example cases. The first one relating to horizontal relationships where, for example, a research joint venture is set up where the parties argue that they would only assign their key personnel to the joint venture if they are certain enough that the other party will not poach their best employees, which is, I think, a scenario that's very relevant in practice. And the second scenario relates to vertical relationships, where the parties argue that without the no-poach, they would not enter into it when they have some sort of subcontracting agreement, for example, supply relationship or the like. The policy brief is addressing the risks of the companies. Ask for one, the risk of losing investments in the employees for training, etc., and secondly, losing IP that's not protected, non-patent IP, for example, trade secrets or some sort of know-how that employees have developed or learned. So these are the risks that are associated with that. And then the policy brief reiterates the 4 strict conditions that are very familiar from the other guidelines, which is, just to briefly repeat, there has to be a main non-restrictive transaction. The restriction has to directly relate to that transaction. The restraint has to be objectively necessary for the main transaction, and the restraint has to be proportionate to the main transaction, meaning there are no less restrictive measures. And that, of course, means that the scope must be clearly limited. Only those employees that are directly involved. Duration has to be justifiable, and of course, the territorial scope has to be limited to what is necessary. So this is all quite familiar, but the fact that the policy brief says it will be a very high hurdle to reach that is sort of bad news for practice, I think. And the policy brief mentions there are often less restrictive measures available, such as confidentiality agreements or non-compete clauses, but this will not always work in practice. So I think we're seeing really a high relevance in practice here.
As you say, the risk assessment for companies and their advisors in this scenario where you've got a neutral or pro-competitive arrangement and you're trying to argue there's an ancillary restraint attaching to it is going to be difficult in many cases. So looking at some live examples, Johanna, we've mentioned some of these briefly in passing. I attended the fairly recent international cartel workshop in Barcelona, where the Commission, the Portuguese regulator, the CMA, and others were all making lots of references to labour market cases. As we're recording, I think there are about 13 pending in EU national jurisdictions. Jaclyn referred to EU activity. So could you just tell us briefly what, so far as is known, the EU is looking at in terms of live cases as we stand here, and also 1 or 2 interesting national cases that we know about as well. I referred to the Portuguese, but feel free to go beyond Portugal, if you prefer.
Yeah, indeed. A lot of cases going on at the European Commission level. The one that's prominent in the public is the dawn raid that was conducted in November 2023 in online food delivery companies on suspected no-poach agreements. And apparently, this is the continuation of a dawn raid back in July 2022 that was based on restrictive agreements or restrictive business practices overall, which were not specified at the time. And then apparently the scope was widened in November 2023. Interestingly, potentially, the two companies involved, they were in a merger in 2022. So this may have actually been kicked off by a merger. And then there was a general dawn raid, and that was more specified then to go into the no-poach agreement. We don't know how this is moving on so far, but we'll see what will be brought here. In the policy brief, it is mentioned that most cases will most likely be rather national in scope and not that much on EU level. But the European Commission also states that they will, of course, closely monitor and follow any leads, and they will coordinate cases within the European Competition Network, which corresponds to the opinion that this is really an enforcement priority at the moment. Portugal, interestingly, has been extremely active in the labor market cases. There are quite a number of them. The very recent one is on no-poach agreements in the technology consulting sector, where the parties committed not to hire or make unsolicited offers to employees of the competing companies. 3 companies apparently already settled with fines having been imposed, lower millions area. Another company was not willing to settle, and so this investigation is ongoing, and the so-called statement of objections, so the accusation document was issued end of May. Will be interesting to see how that moves on. Since they have not settled, I'm kind of hoping that they're going for some sort of ancillary restraints arguments and that they will take that case to court, but that's of course still a long way to go. Apart from that, we've seen a number of cases in the area of team sports regarding no-poach, especially also in Portugal, but also regarding wages, for example, in Poland on basketball. That was stemmed from the COVID pandemic. A lot of cases are referring or are relating to engineering or technology consulting, for example, in Romania and France. The UK has proceedings in the fragrances sector and film production and distribution. So there's really a number of cases going on. Also, there are cases, and I mentioned that before, where associations have been giving recommendations for payment of independent suppliers or employees, which is also being looked at. And a number of NCAs by now have issued some sort of guidance on where they want to go, what they think about these labor market agreements. And enforcement actions have been taken in a couple of countries. Interestingly, though, a lot of them that stem from the past few years were in the context of broader investigations, where the actual investigation related to another type of infringement. But there was, for example, a case in Germany where film production companies were fined for information exchange of commercially sensitive information. And one of the pieces exchanged, and that's also briefly mentioned in the case, is the cost of personnel and surcharges for weekend work. So we have seen these elements. So far, not that much standalone, but the cases have now kicked off.
So a very wide range of cases. I thought it was interesting. I heard the head of the Portugal regulator comment recently, again at the workshop, making the point specifically that they're looking at a case involving alleged wage fixing and information exchange, quotes, in anticipation of negotiations with unions. And he was keen to point out that this related to, again, quotes, middle and low skilled workers. So not only, it's not only high tech, IT, etc., but they're looking across the whole range of types of workers.
That's indeed an interesting aspect, and we have not seen such cases, or I have not seen such cases so far. It was usually around highly skilled workers, especially the no-poach, of course. But for the wage fixing, I suppose there's a lot of room for companies to agree on restrictive price fixing there.
One question that companies that operate in the U.S. might have is whether employer-employee non-competes have been in the crosshairs in all of the enforcement that you've been talking about. Obviously, that's a big topic in the U.S. with the FTC's final rule that just came out, but that, of course, was issued under Section 5 of the FTC Act, which is focused on unfair competition. So just wondering if you've seen that at all in your European practice.
Well, under EU competition law, the cartel prohibition of Article 101 does not cover this type of non-competes. The European Commission is of the opinion that it's not an agreement between undertakings, which is probably correct. And usually these non-competes are regulated by national labor laws. They're usually that's a less restrictive way of dealing with protecting employers' interests. And national labor laws have, in many European countries, pretty clear rules on how this is going to work. I think during employment time, there is a sort of tradition, even if it's not explicitly stated in the agreement, it's the employee's duty of good faith or loyalty. It's a loyalty obligation not to compete during the time of the employment with the company that's the employer. That's, of course, limited to the activity that's relevant for the success of the company. And Matthew, you mentioned that issue before of what are we actually looking at? If you have a secretary writing IT staff working for a biotechnology company, it would usually not be a problem for that person to do a similar thing with a competitor. I think the matter of interest in the non-compete issue is the post-contractual non-competes. How do you deal with that when you're losing an employee to a competitor? And here there are, I think, slightly different approaches, but the general assessment seems to be it's okay to agree on this type of post-contractual non-compete if there is a legitimate interest for the employer to protect what I call non-patent IP know-how that the employer has. However, it's a strict requirement that these employees are granted some sort of waiting allowance. So they have to be paid if they cannot work with a competitor following their leaving their current employer. For example, in Germany, that's a pretty strict requirement. The payment has to be at more than 50% of the last wage. So that's quite significant. And I think the idea behind that is also close to the unfair competition idea as discussed by the FTC. In any event, these post-contractual non-competes have to be carefully drafted. They have to be in writing, and a narrow approach has to be taken. But of course, these are transparent vis-a-vis the employee, and they're negotiable. So that's a different category than any sort of no-poach. One final remark on that, I think it's important not to confuse this type of non-compete. That's a good tool for employers to protect know-how that certain employees have when they leave. They can be obliged not to provide trade secrets or other secret know-how when they start working for a competitor. So that's a less restrictive way of protecting employers' interest.
This is a very interesting area raised by Jaclyn, and I think that, as you point out, Johanna, it's often you're going to be looking at member state or national employment law here, and the kind of the similarities between U.S. antitrust. We're looking at wage fixing and no poaching, which is maybe fairly similar to EU antitrust. Quickly falls apart when you start looking at employee-employer non-compete arrangements. There's a very different analysis. You made some very helpful earlier comments about or referred to compliance messages or issues. I think it'd be good to finish off on the substance here. If you could just give us some of what you see as the key highlights that HR should think about here when we're looking at competition law risk in labor markets.
Yes, I think the most important thing is to remember that even if you're not competitors on product markets, on the downstream market, you're still competitors on the labor market because you're all purchasing skilled workers or non-skilled workers. It depends on which ones you're looking at. But that's a concept that has not really sunk in with the companies, not with the companies as such, with the executive level, and neither with the HR people in those companies. Beyond that, I think the two key rules are that you're not allowed to discuss or enter into agreements with other employers, how to recruit, at what price to recruit, etc. And you're not allowed to share information on that. That's the main important rule. But beyond that, I think it's important to understand that HR has to be included in all compliance measures, and HR should be asking for that in their companies. And beware of job fairs, career fairs. That's where competitors meet, and that's what we usually say to companies manufacturing products. When you go to your product fair, beware that you don't discuss with your competitors. And of course, that's the same, absolutely the same on any type of job fair where you are meeting competitors, hiring equally skilled people for their companies. I think there are also some main takeaways on compliance. Training for HR is rather new, I would say, 5 to 10 years ago. Usually when you were doing compliance trainings for companies, you would exclude HR from the group of people that should attend. I think that has absolutely changed. Also, audit existing employment agreements for potential risk areas. I think that's something that will help you flag risks. Evaluate how business is accessing information and where does HR get salary information from? How do they sort of price their purchase of labor force? Review existing cooperation agreements. Do they really meet the criteria for ancillary restraints? And I'm sure most companies have this sort of cooperation agreements, whether it's R&D or whether it's subcontracting, supply agreements, whatever. I think the non-competes are a lot more, non-competes are a lot more present than people think. And of course, ensure that if you agree on a non-compete clause post-contractually, make sure that this is done in the correct way. And a final note, if I may, in the transaction context, I think that really adds new flavor because we only start dealing with the issue of, that's a transaction between competitors when they're competitors on the downstream market. But of course, now we're learning, no, you have to watch out. Even if they're not competitor on the downstream market, they may be competitors for labor force. And now, since this is an enforcement priority, this will have to change the way we advise or support our M&A colleagues or clients when doing this type of transaction. So I think that's another sort of side takeaway I would want to make.
Thank you so much. This whole conversation and all those insights is, so important in this world of heightened focus on labor issues. And I'm sure our listeners appreciate the global perspective on this. We don't let any of our guests leave before we learn something about you. So tell us something interesting or unusual about yourself that we may not know only from working with you.
Well, I've always been an enthusiast in sports. I've done a lot of team sports, so this is one of the reasons why I'm so interested in the labor market issues, because a lot of these cases are in the sports area, and I have sort of a past in team sports, which I miss. Many people know that. I was a handball player. Team handball is a very European sport, not very known in the US. I did some ice hockey, but one of the highlights was when I briefly touched the Olympic torch riding on the subway in London in 2005, when London was awarded the Olympic Games for 2012, and there was a parade where the Olympic torch was carried on. And I was lucky enough to be there for a moment and to be able to hold that. So that's sort of the lightening up of my sports career, which is, of course, long past.
That's very cool. Are you excited for France?
Absolutely. And by the way, 2005, when London was awarded the 2012 Games, they won over Paris, who was running the Olympics.
All right. Fun fact.
We're seeing that this year now.
Well, go USA. Thank you so much. And to our listeners, thanks for listening to our Curious Amalgam.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.